Welcome to the Estates Made Simple podcast with Jenna and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to Estates Made Simple. I'm Jenna of Guardian Estate Company. I'm here with my fantastic co-host, Gordon Vanderleek of Vanderleek Law. And we're really excited today to talk a little bit about some interesting things that most executors don't know about estate administration. I think we've touched on these points in previous episodes, but really just highlighting the three most interesting things that people may need to know and the importance of each. So Gordon, perhaps I'll let you start. What's the most interesting thing to you when it comes to estate administration?
Yeah, as we talk about the whole probate process and the start of the estate administration process, it starts with that grant of probate, right? People get that court order that will give them the legal authority to be able to begin to administer the assets of the estate. So you got to go through that application process. The end result is the grant of probate or a grant of administration. But when we're looking in the event there's not a will, but what's interesting when you look at when people talk about their will, they go, yeah, you could argue a relatively private document. It's not, there's no public registry for wills. It's not like anybody else can see it. The only person who sees your will is who you share it with. But when you pass away and a spouse or your kids on your behalf or whoever you appointed as executor has to go through that process, they are engaging the public system, if you will, through the surrogate court in this application process. The will itself often is circulated in advance that people will see it, but that may be specifically to the beneficiaries. Recognize that while there's a lot of privacy on the planning side of it, there's a loss of the privacy when you go through the probate process. And the starting point is every probate document, anything you file at the court with regard to probate is public. I can go down, and if I know somebody passed away 5 years ago and I have their correct name, I can do a search and get a list of here's all the documents that are part of the court file. And for a fee, I can get a copy of those, right? So from that perspective, while there's a sense of privacy on the planning side, that privacy is lost once you go through that process. So I think point number one would be it's a public document, right? And it's in there. I've seen some wills drafted where they almost begin to say some very, especially ones where people do things themselves or it doesn't involve a lawyer, where they say some disparaging things or some things that they regret, or particularly they assume only my beneficiaries are going to read it, but it becomes a public document. And certainly if there's contention, then it's part of a reported decision. But the actual court order, just to illustrate, when you get that grant of probate, it's a one-page document that has a signature of the justice. But attached to it is the certified copy of the will that has been submitted through that process. So if it goes to Canada Revenue Agency, they're going to read your will, right? If it's submitted to land titles, it's there and people can see those documents. It's not to say that creates a problem, but it's interesting to know that there is a public nature to those documents. Where that translates or makes a difference from a planning perspective, the odd time somebody is coming to me and saying, I really don't want this to be public, right? How can I structure my estate in a way so it remains more private? So now we're into trust planning that wouldn't involve going through that surrogate process on that. So I think that's something that may not be obvious to everybody, or maybe a point that is lost because it starts in a private nature. How
Right.
about you? What's a takeaway or a thought with regard to something a legal representative of the estate may not know?
I think one of the most important things is that an executor, a personal representative, can be held personally liable for any mistakes made in the course of the estate administration. And I think this is surprising because a lot of people think that if you have the best intentions, you try your hardest, you do everything with integrity and honesty, if you make a mistake, then the court will be forgiving. And that is not true. Executors have been held accountable to actually reimburse the estate for any downfall in the value of the estate. And so that could mean that the executor has to pull from their own assets. And this all means that an executor should really consider before they start acting if they want to take on that risk. And of course, there's ways to mitigate the risk. There is executor insurance you can take out. There's indemnities you can get the beneficiaries to sign. But just knowing that any mistakes made, even if you're well intentioned, could hurt you in the long run. That definitely highlights the importance of getting experts in your field and making sure that you have the right people beside you during the course of the estate administration.
Yeah, absolutely. And because I really like your point on that to say, of course, they just know I'm trying the best. So that's good enough. Right. But there is an objective, there is a standard, right? That's applicable to executors in terms of performing their duties. There's legal responsibilities. And if they make a mistake, then they can be held to account. And you never know where you may assume a beneficiary should just be grateful that I'm in fact doing it and I'm giving them some money. What are they ungrateful for? But it really highlights the need to be managing that risk
Yeah.
throughout the administration of the estate. So that's an excellent point. Another one that comes to mind as just to wrap up for maybe a third point here would be I've seen it happen probably more often than maybe it should, is where executors are not aware that they can decline the appointment.
Mhm.
I think there's this sense of I've been appointed, I have no choice. And they do have a choice, right? They could say no. The difficulty is they might realize they should say or want to say no a little bit too far into the administration of the estate. And I think in prior episodes, we've talked about what's the process that you have to go through to get out of that situation. But they can choose. There's a choice there, but you need to do, I think, the theme of prior episodes and a good point to reemphasize is that should be done at the front end. Halfway through the administration of the estate, if you say, I can't do it anymore, that maybe is the right decision to make, but it gets a little more complicated in terms of implementing that. Having the opportunity to do a good evaluation, get some advice before you step into the role and get too far into it, I think would be appropriate. And when we talk about it from a planning perspective, if you're going, wait a minute, I've chosen some executors, having conversations with them about the fact of, are they willing to serve? What is involved? Educating them, maybe forwarding some episodes of Estates Made Simple to say, hey, there are solutions here, and just making sure people are on board. Because maybe on the planning side, somebody says, I'm going to nominate my friend. Of course, he has to do it. No, it can decline, right? It comes up sometimes in that context as well. You want to secure the right executor and make sure they've consented to serve so we don't have a problem that the estate starts with some uncertainty as to who the executor is, or maybe there's a court process involved and additional expense. But just being aware, I guess the takeaway being aware you can decline and to do that in a timely manner. And if you're not sure, get legal advice with regard to that item.
Along the same lines, many people think that you have to consent before somebody actually appoints you in their will. And that's not the case either. Lots of people appoint executors and they have absolutely no clue. The executor has absolutely no clue that they've been appointed. And so there's a little bit of a disconnect there. So I like your comment about talking to your executors beforehand, making sure they're going to act, or at least they're in the right mind to act when the time comes. So thank you for those points, Gordon. Thank you to all of our listeners for joining us today. Please feel free to subscribe to wherever you listen to podcasts, view our beautiful faces on you, and we look forward to seeing and hearing from you next time. Thank you very much.